Hi, good afternoon to all. I'm Ashish Verma, and I'll be discussing something about judicial activism in India. We know India got independent in 1947, and in 1950 we gave enforcement to our means we adopted, enacted, and gave to ourselves our constitution. The constitution, to a certain extent, follows the separation of powers, and the three wings of governance are established by the constitution itself. That is the legislature, executive, and judiciary. Of course, the three wings have their own works and they are supposed to be functioning within their domains. But there are certain intervals, there are certain occasions wherein task of one wing is not completed fully and so nicely as to be completely flawless. So there's some filling of gap done by the other two wings, and when it comes to the filling of gaps, judiciary has taken up the task of consolidating it at different occasions, and this has had so many dimensions of uh, judicial activity, which is often termed as judicial activism. So let me first start with the idea okay, why we call it judicial activism. The routine activity performed by judiciary and the routine activity performed by the other two wings, they are very general. Completing it up to that extent will not lead to any type of activism. That's routine. That's generally done. Well done or maybe slightly poorly done. But whenever some party moves ahead and does something which is it's not generally supposed to be done or not generally done in all jurisdictions, that is termed as activism on the part of that particular wing of governance. Judiciary has been very active since the very beginning of the Indian Republic and its constitution. Law regulates human conduct. So well known, we all know that law regulates human conduct. And human conduct has so many seen, unseen, and unpredictable dimensions of itself. So regulating it by law, especially by the statutory law, is very difficult. Lawmaker at the time of making a statute, at the time of enactment, they predict certain situations and answers to all means hypothetical judgment of all those possible situations is to be contained within the provisions of the law. It is impossible, practically impossible, to envision all possibilities, all such circumstances, and write down the judgments of all of them within the legal language of the provisions of the law. So provisions are good, provisions are sufficient. The Benthamite thought of law being so complete as to be there being no need of judicial interpretation or discretion. This is practically such an ideal situation that is not possible to be had by any jurisdiction. It has never happened anywhere in any country. However, in India, situations to the contrary have happened far more since the very beginning. So let's know how our judiciary is and what is the judicial setup and what all affinity it has, because Indian Constitution is said to have received inspiration from different constitutions of different countries. It is said that the fundamental rights have been borrowed from the United States. It is said that the idea of directive principles has been inspired from the Irish Constitution, and similarly, the parliamentary form of democracy has received inspiration from the British setup, British polity. Similarly, the Indian judicial setup seems to be closer to the US setup. I don't mean that it is exactly similar to the US judicial setup, because in the United States, the judiciary is in, say, two-tier kind of thing, wherein in every state there is a Supreme Court. In India, there is just one Supreme Court for the whole of the country. Maybe very much like the single citizenship and dual citizenship, it was a demand of the means integration of the country, which was already so diverse as not to be open to those fronts. So it was made a single tier judiciary. Otherwise than that, the hierarchy of subordinate courts, the district courts and other subordinate courts, and then above them being the high courts and above them being the Supreme Court, this is closely similar to the United States judicial setup. We follow that. Coming to the differences, one is very clear. Indian judiciary is a single tier judiciary, single hierarchy of courts, and in the United States there are double hierarchy, means Supreme Court in each state of United States is there. So this is one of the major most differences. Apart from that, Indian judiciary is established to be an independent judiciary. US judiciary is also supposed to be independent judiciary, but to ensure independence of judiciary, there are so many measures taken. Upon those, we are different. Judges cannot practice in the courts which has been in their jurisdiction or where they have been the judge. This is similar, India and USA. Judges do retire after 65 years if they are from Supreme Court, 62 years High Court. In the United States, the Supreme Court judges never retire. They can resign, they can take voluntary retirement, otherwise they don't retire. This is just to ensure the independence of the judiciary. This is one of the elements of the independent spirit of the judiciary. In India, judges are not allowed to take up practice in the litigation assignments. Apart from that, things are open to them. Now coming to the jurisdiction of the Supreme Court, jurisdiction is relevant here because judicial activism raises a question. If it has been something extra which is not in the routine function of the judiciary, which is not generally expected, then was it within jurisdiction? If it is within jurisdiction, then how come it is activism? It must have been within routine. If it is within jurisdiction, it has to be expected of them. In fact, things are not that objectivized. There is some subjective space left, very much contrary to the thoughts of Jeremy Bentham and Blackstone, who were the well-known opposers and the enemies of judge-made law. Things are, when they come to the practical plane, discretion cannot be denied. In the jurisdiction part also, there are so many things which are open to the discretion of the court. The writ jurisdiction is very much open. Jurisdiction is generally had in three parts. When it comes to Supreme Court, three type of jurisdiction Supreme Court has. One is the original jurisdiction. A writ jurisdiction is an original jurisdiction of the Supreme Court. However, a concurrent original writ jurisdiction is had by the high courts also under Article 226, and Supreme Court has it under Article 32. Basically, the purpose of Article 32 and the relevant jurisdiction is towards protection of fundamental rights. Article 32 itself is a fundamental right, the right to constitutional remedies. Right to get a remedy is also a right. But it is not restricted only to the individual instances of fundamental right violations. Means practically it can be said like, but technically going, nobody can say it's beyond fundamental rights, because whenever a petition for under Article 32 is filed, the first confirmation is taken whether it relates to fundamental rights or not. So the scope of fundamental rights itself has got expanded. And a bigger thing is about locus standi. If it's about individual instances of violation of fundamental rights, then locus is had by only the person who has faced the instance of violation, the breach of fundamental rights. In fact, courts have been open on this point that in India, the populace is largely uneducated and unaware of their rights. They are largely unassertive also. So any public spirited citizen, in light of the doctrine of waiver, that nobody, if even if someone is not knowing his rights and his rights have been violated, the person does not have a right to authority to relinquish his fundamental rights. He has a right to protect it. Rather, he must protect it. So the expansion of locus standi happened only on this premise that a person cannot give away with his fundamental rights. So any public spirited citizen taking up the cause of the public in case of breach of fundamental rights can file a petition on behalf of the class which has seen the violation, and it has happened. So the expansion of locus standi, and further the format of this petition. This is also not restricted, not given. There have been instances wherein a newspaper reporting was taken up as a public interest petition. I remember one of the esteemed guests in our university sharing his experiences with us, told that in the case of Neelbati Bera, said the person says that he was the chief justice in that court, and having seen a lady in the court sitting in a particular posture at a place where nobody was generally supposed to come and sit, he just got a thought: nobody would come here for a picnic. What has happened? So he sent his orderly, and when the orderly comes back and she says that her husband and son have been lifted, they have been taken up by the police people, and there is no information about them for the last 7 days. Then the judge says, register a petition for habeas corpus and raise it when I am sitting in the court. So the form of the petition is not necessarily to be given in a particular shape or a particular format. There have been instances where a letter written to the Chief Justice of India was also taken up as a public interest petition. So in view of all these things, and further to it, the remedies, Article 32 itself says that not only the remedies in the nature of the listed writs, there can be some other remedy which the court may devise if the court finds it necessary, and court feels that it would be sufficient to give effect to those fundamental rights. Court can issue that. So in light of all these things, it's not been only about the violation of individual fundamental rights. There may be a law. There may be a law which is likely to violate the fundamental rights of the citizens. That law can also be taken up to to the test for its constitutionality, whether it qualifies or not. Because any law that sees any contravention on any aspect with any of the fundamental rights is void to the extent of such contravention. This comes within the original jurisdiction of the Supreme Court. I will not discuss the original jurisdiction of the Supreme Court towards the interstate disputes or dispute between center and state. I will not take it up because that is not going to relate much with the judicial activism thing. However, Supreme Court has that jurisdiction also, and there can be uh, some instances of judicial activism on that part also. That would make it too lengthy. Coming to the appellate jurisdiction thing, Supreme Court is largely an appellate court because even the high courts are appealed from, high court orders are appealed from in the Supreme Court. So a person who has not been able to get remedy from a high court up to the level of a high court goes to the Supreme Court. However, it is pertinent to mention that right to appeal is a statutory right. There is no inherent, there is no fundamental right to appeal. So long as it is provided that an appeal from such an order from a high court or from any court, so long as it is provided in a statutory provision, there can be an appeal to the Supreme Court. That comes within the jurisdiction of Supreme Court. And third one is advisory. All these jurisdictions have been utilized at occasions for giving out something which was not earlier supposed to be the existing law. In the advisory jurisdiction also, the, the words of Article 143, which provide the advisory jurisdiction to the Supreme Court, they are very clear that President may refer to the Supreme Court certain questions of law, and Supreme Court will answer. It is a rule Supreme Court has accepted. Whenever President refers certain questions, Supreme Court will respond. But Supreme Court has confirmed it in uh, cases that if the question is not having, if the referred questions are not having any question of law, if the questions, if answered, are of purely political nature rather than of legal nature, Supreme Court may not answer. But Supreme Court will give reasons. Supreme Court will give its response to the President of India that these are the reasons, so for which we are not responding. All these jurisdictions have been utilized by the Supreme Courts very effectively for the purpose of uh, providing its role in the name of judicial activism. It is also expedient to mention that high courts have also been a part of the judicial activism. It is not meant that only Supreme Court has been the active judiciary. High courts also have some such jurisdiction where they can determine the questions of law, and largely Article 226, the original jurisdiction of the high courts, which is a writ jurisdiction, has been utilized for this purpose. Be it an executive action, be it a law, or be it an individual instance of somebody's fundamental right violation. On all those occasions, high courts have been assertive, and there are cases on it which we will be discussing in the later part of the discussion. Now coming to the next slide. The spirit of judicial activism is well connected with the independence of judiciary, because judiciary, if not independent, will never be able to be that activist as it has been so far in India. Judiciary felt independent. Judiciary felt empowered to do certain things beyond lines. So it did. Now, to understand the independence of judiciary in brief, independence of judiciary was much thought of. Article 50 of the Constitution, which is in the directive principles of the state policy, and by the very nature of the directive principles, it is not enforceable through writs, but it includes, it contains, and it is connected with the spirit of the Constitution, which means to convey what Constitution and the Constitution makers intended to be like. It was intended that the judiciary shall be kept separate from the executive. Very clear purpose is to ensure judicial independence. Very well said that Parliament, especially the House of the People, has the power of the purse. The entire consolidated fund is controlled by the Parliament, especially the House of the People. They have the power of purse. Executive has the power of sword because they are the enforcement agency. This wing enforces the law. So they have the power of the sword, which is the most effective power towards utilization or misutilization in a coercive way or in a positive way. It's all open. No one means that executive will use it negatively, but law has to be cautious. This cautious approach of the constitution makers was visible in Article 50 when they talked of separation of judiciary from executive. That if it is kept separate, then the likelihood of such exertion of power or influence exercising over judiciary to get judgments of their choice will be too little. So judiciary was to be made independent. The basic purpose of fundamental rights is to restrict state action. That's why most of the provisions in Part 3 are in negative language. State cannot do this. The state shall not deny to any person the equality before the law and the equal protection of the laws. The state shall not discriminate. No person shall be deprived of. So this language is generally suggestive of a restriction on state action, what the state cannot do. So whenever individual and state are parties, independence of judiciary matters a lot. Unless the judiciary is independent, justice cannot be much expected. So this is one aspect. Second is separation of powers. Separation of powers was given by Montesquieu basically on the premise that power corrupts. Power corrupts, and if absolute power is available, that corrupts absolutely. So to avoid concentration of power to the level of absoluteness in any of the governmental department or wing, it was thought of to separate them up. Judiciary will be functioning within the judicial domain, executive will be functioning in the executive domain, legislature will be functioning in the legislative domain. However, separation of powers practically and fully, absolutely cannot be implemented. Nowhere it is. The US Constitution, which is often cited as the ideal repository of this doctrine or application of this doctrine, that also does not have separation of power in the full sense of it. But the spirit of separation is present. In India also the spirit of separation is present, especially to the dimension of judicial independence. Judiciary has been kept fairly separate because in a parliamentary democracy like India, separation of legislature from the executive is impossible. So we understand the separation of powers, at least to this extent, is there, and it has also been confirmed by the Supreme Court in the case of A.R. Antule versus R.S. Nayak. Supreme Court once had this question whether separation of powers is applicable in India or not. Court said that separation of powers in the strictest of the sense is not applicable, but the spirit of separation is present. So whenever practically possible, separation has been done. So far as practically possible, judiciary has been kept separate from the executive. Next point is independence of judiciary as a federal element. Federalism is completely a separate thing from judicial activism. However, but there are interlinkings. Law is something which is very integral to all those things. They are all connected from some aspect or the other. Independence of judiciary is not solely for the purpose of ensuring impartiality in judgments between center or state, sorry, individuals and states and all. It is also between center and state, the two different units of governance. That is its connectivity with the spirit of federation. Whether a country is, whether its constitution is federal or not, this thing on depends also on the degree of independence of the judiciary. Independence, no one can talk of absolute independence, but judiciary is fairly independent so as to comply with this demand of federation. Being federal again means not concentrating power. Power is not concentrating only in the central organ, rather it is decentralized. From center it is decentralized to the state. India has seen further decentralization, and the third tier of governance has also been added by constitutional amendments and passage of legislations. So independence of judiciary is important from these three aspects, and there are a number of constitutional provisions which try to conform to the spirit of separation or to the spirit of independence of judiciary. Article 122, it is provided that discussion on the conduct of a judge shall not take place in the parliamentary house unless the motion for his removal is on. So this provision also has a purpose, and the purpose is solely to ensure that judgments are not made a matter of discussion in parliamentary houses. But however, whenever the motion for removal of a judge is on, then that has to be there. And that is also done within the ambit of the constitution. So this is about independence of judiciary, and judicial independence has its linkages with judicial activism. So this part is done. I'll come on to the next slide, which is about judicial independence and judicial review. Judicial independence, judicial review, and judicial activism. All three are connected now. So I believe judicial independence is fairly discussed. Now we'll link it up with judicial review, judicial activism, and judicial review. Judicial review is said to have originated in the United States of America when the famous case of Marbury versus Madison was decided. It was Justice Marshall who wrote his comments on the power of the judges power of the courts to review a piece of legislation made by the Congress. Remarks also came from the then President of America whether the congressmen are to be taught by the judges how to make a policy. Answer could not be in yes or no, but the judgment that came out in Marbury versus Medicine was very clear that a law made by the parliamentary houses, the Congress in the US, that is never final in itself. It has to conform to the judicial ideals. Here, I have a strong personal opinion on this point. Every law has to pass through the merit criteria, and the merit criteria has to be seen in two components. One is the democratic component. To get passage in the parliamentary house, the number game is important. If the democratic component is satisfied, people are agreeing, more and more people are agreeing, even if 100% of the members of the parliament are agreeing, that does not mean the thing is 100% right. Maybe, maybe that the majority confirms or majority agrees on something which is not well correct. So, the second component is the judicial component, or you may call it the meritorious component or the substantive component of right and wrong. Can some wrong be converted into right if the majority says it is right? It's from one technical legal requirement point of view, somebody can say yes, it is right, law can be made. This discussion has taken place on several occasions, in several cases also, and some of which we'll discuss in this uh, discussion. But here, it is to confirm on both the points. The Marbury versus Madison judgment is clearly to point out that conforming to the judicial thing is the judicial component or the merit component is open, and Supreme Court has sufficient jurisdiction for doing it. So from that case, and that case was decided, and that became a celebrated case in the United States legal history. And after that, it is said that having inspired from the judicial setup of United States, India also moved towards that side, because if some law is made and that law is not very proper, is violating the fundamental rights, or otherwise that law is not very proper. So judicial review, it is open to judicial review. All that I mean to say is that it is open to judicial review, and the inspiration has come from the United States of America. In India, judicial review has the same jurisdictions. Article 32, Article 226, maybe some other provisions also, because it is judiciary which interprets that this thing is well covered within this jurisdiction. The court itself decides whether it has jurisdiction or not. So in India, also judicial review is possible, that is provided. Article 13 of the Constitution talks of the review possibility in terms of fundamental rights. Judicial review can be seen in two parts, and to be systematic in three parts. Third part I'll deny at the end of it. First is judicial review of legislative action. Judicial review of legislative action simply means that a legislative action has been taken place. Legislative action means a law has been made. Maybe there is something which requires a law to be made for that. For example, imposition of a tax, that also is a law. New tax can be levied only through the process of law. So law is made, new tax is imposed, or maybe for anything, law has been made. Law has been made, it is a legislative action. This legislative action is subject to judicial review, and there are instances. Cite some instances which will also justify the need of judicial review of legislative action. However, this will be partially in conflict with the doctrine of parliamentary sovereignty. So I'll take little time, it's 1 minute or 2 minutes to discuss parliamentary sovereignty also here. There is no doubt important. Not only in light of separation of powers, but also in light of finalizing things. Legislature is the wing that is responsible for making laws. They have made law. Unless they are independent, very much like the judiciary. Judiciary needs to be independent. Why not legislature needs to be independent? They need to. And for this, the doctrine of parliamentary sovereignty was evolved. In Britain, the parliament is supposed to be having the parliamentary sovereignty. Parliament is the most powerful. Even at times it was said that the British House of Lords is so powerful as to convert a man into a woman and a woman into a man. So if they declare it, that's final. There cannot be any further challenge to it. There is no appeal from it. So that is final. That was the sense of parliamentary sovereignty. British constitution is unwritten, so their powers are also unfettered. They decide. whether we have this power or not. So in that sense, they are more towards parliamentary sovereignty. But the practical needs of the time and of the population, that also needs to be justified. And even the sovereign British Parliament had to see a compromise on that front. The European Communities Act was passed, and after that European Communities Act was passed, the European Community Law automatically is binding on the Britain, even if the law of the European Community is somewhere in conflict with the law of the land. So the doctrine of parliamentary sovereignty, even in Britain, had to be means, relaxed at certain points. That means it is a practical need of the time that means, no particular wing can be supreme in any domain. That's why it is said that the doctrine of separation of powers is no more workable. Now is the time of uh, checks and balances, the doctrine of checks and balances. And that is the doctrine which operates largely in India, in USA, and in most of the countries. So that is again a justification for judicial activism and judicial review towards review of legislative action. In 2002, there was a case. That's an example of judicial review of legislative action. The then Indian Parliament made a law that was to amend the People's Representation Act. People's Representation Act was amended to reduce the liability of the candidates for contesting elections. It was passed, and the liability reduction was on the front of releasing information as to their education, information as to their property, assets, liability, and antecedents, any criminal background, any cases filed against them, etc., etc. So that liability was diminished and the act was passed. And I find it interesting to note that the president had once returned the bill and it was again sent back to the president and he had to pass it. And that became an act. That was the complete legislative action. But this legislative action was challenged by the Association of Democratic Reforms, which is an organization working and researching in the area of democratic reforms, electoral reforms, and all. They challenged it through a writ petition under Article 32. Supreme Court found it worthy of interference, and court said that under Article 19(1)(a), the right to fundamental right to freedom of speech and expression, it is well included that the electorate has a right to know the antecedents of their candidates. Unless they have information, political choices cannot be made. And towards a mature democracy, towards a successful democracy, this right of the electorate is very important, so important as to be included within fundamental rights. And casting of a vote is also an expression. This expression is making of a choice. Uninformed choice is it's not a good choice. So uninformed choice being a compulsion is violation of this fundamental right of speech and expression. The right to know their candidates while expressing the casting of vote. So court turned it down, the legislation was frowned upon and court held it unconstitutional. This is one instance where not only reviewed but turned down. Court said this law is no law. Next example comes from the recent and very famous NJAC, National Judicial Appointments Commission Act. Act was made, act was challenged, and a time came when the act was finalized and then challenged. That was the Supreme Court Advocate on Record Association. Supreme Court has recently held that this act is unconstitutional, means the procedure of appointment of judges will continue to be through the collegium. The collegium system was evolved by the Supreme Court itself in another means this Supreme Court Advocates on Record Association case of 1994. So both these cases are examples of judicial activism towards appointment of judges in the courts of record, High Court and Supreme Court. This is one aspect of judicial activism, which is also an example of judicial review of legislative action. Law was made, judicially reviewed, and turned down as unconstitutional. Next example, because we need to take examples of other kind also. So I have taken the example of Kameshwar Singh versus State of Bihar. It's not a new case; it's an old case when the 42nd Amendment was made to the Constitution to delete, to omit, and to repeal the fundamental right to property. Article 19(1)(f) was repealed, and it contained the right to property. It was repealed. No further right to property. Question is, okay, Article 13(2) clearly says that any law which violates contravenes, takes away, or abridges any of the provisions of fundamental right shall be void to the extent of such taking away, contravention, or abridgment. So that amendment to the constitution should also have been null and void, ineffective, unconstitutional, zero. But when questioned, Supreme Court reviewed. First thing is Supreme Court reviewed that piece of legislation. That was a legislative action which was reviewed judicially. Judicial review was done and court found that the legislative action was appropriate. It is not only about one provision or the two provisions. Constitution has a complete scheme. Constitution is not only a compilation of certain provisions. Constitution is not only towards establishing certain institutions, organizations, and offices, not only the legislative, the executive, and the judiciary. Constitution also contains a rhythm of mobility of these constitutional institutions and extra constitutional institutions as well. That rhythm lies in the constitutional philosophy. The constitutional philosophy containing the scheme of the constitution was not violated. Court says that it is very much in line with the idea of the constitution and it works towards reducing the gap between rich and poor. It is one of the ideals of the constitution contained in Article 39 that the state shall orient its policy towards ensuring common good, towards ensuring that the material resources of production distribution are under control of the community and not in the private hands. And all this will operate so as to reduce the gaps between the rich and poor to avoid concentration of wealth. And if Jamindari abolition laws were not made, then concentration of immovable property was there into certain hands, and the majority was landless laborers. So whosoever uh, gets profit, whosoever gets loss out of this action, but the constitutional scheme was being satisfied. So the Amendment Act and the Jamindari Abolition Acts, which were made in course of that, it was not held to be unconstitutional. Court says it is very much okay. That means here judiciary has confirmed one thing, that judicial review is not only available, legislative action is not only open to judicial review, but the bigger thing is that judicial review is not meant for asserting the authority of the judiciary. Judicial review is towards confirming the substantive component of merit apart from the democratic component. So even if both are in line, means the legislative action is appropriate, judiciary can review, and the final outcome may be that the act is okay, like in the case of Kameshwar Singh versus State of Bihar. The legislative action was approved. Further to it, in 2009, in IR Koilu versus Union of India, court has held that even in the ninth schedule, the legislations which are made and kept under ninth schedule, they are also open to, they are amenable to judicial review. And further, the judicial review is a basic feature of the constitution. That means if there is an amendment which tries to uh, give away with the idea of judicial review, that will be not okay, that will not be valid, because that's a basic feature of the constitution. I'll not get into the details of what are basic features and all. They are inviolable features of the constitution, and this is sufficient at this stage, because that will divert the lecture into a slightly different direction. So this is about judicial review of legislative action with examples. Second component is judicial review of executive action. Very much like the legislative action is to conform to the merit component, the judicial merit part of it, executive action is also required to conform to it. And in case of executive action, it is more so because executive has to deal with the day-to-day circumstances in which at times individuals are to take action, individuals are to take decisions, which many a times may be missing some particular component of merit or justice. So they are open to confirmation by the judiciary. If challenged, judiciary may review it and decide. Recently, a very much talked about case happened when a PIL was filed by the Dhar family in Kolkata High Court. So it was about Durga Puja, the Bijoy Dashmi, and uh, Muharram happening on the same day. No doubt, it was a big challenge for the administration and the executive because they had to ensure that all passes smoothly. For this, they tried to manage it in such a way that they said Vijayadashmi should be completed a day in advance and Durga Pratibha Visarjan has to be done early. And on the particular day, only Muharram and the related proceedings will be done. Petition was filed by, this was a PIL, it was a public interest litigation filed by the Dhar family, and court says, okay, this is not okay. This executive action is not confirmatory of Article 25, the right to freedom of religion, practice, profess, and propagation of religion. Both the religions are equal. All religions are equal. In fact, court has said here in this case, two religions are involved. Court says both the religions are equal. All are equal, and the state has to manage with the affairs of both of them on the same day if the festivals of the two communities are falling on the same day. They have to manage it both on the same day. If the government is incapable of doing it, government should be accepting its failure rather than playing with the festival dates and festivities and rituals of the religion. So this became very much talked about, but this was a review of executive action. One example. Second, and a bigger and much bigger example comes from the judgment of T.C. Wadhwa versus State of Bihar. This is a case related to passage of ordinances. Ordinances are executive lawmaking, which is permitted, which is justified, because many a times there are occasions where the parliament is not in motion and there is a subject over which a law is urgently needed. So it is only a provision that law can be made by the executive at its own level, and it can be approved by the uh, legislative house later. In case the legislative house does not approve it, it does not passes the floor test, it will fail and it will die down. However, the ordinance is a law, full-fledged law, till it dies. So long as alive, legally alive, it is full-fledged law, as enforceable, as effective as a statute. There is a huge power given to the executive, and constitution also says that the maximum of gap between the two sessions of legislative houses can be 6 months. Means closure of one session of legislature and beginning of the next session of the legislature cannot be more distant than 6 months. That means for this 6 months, up to this 6 months, there can be an executive law made through an ordinance. And if an ordinance is so promulgated as to have this maximum life, then the next session starts, and within 6 weeks it is to be tabled. So that has about 6, 7, or you may call it 7.5 months of time given to the life of an ordinance promulgated by the executive. So this is the background law related to it. State of Bihar, this power is available with the center and also with the states. In center, president promulgates the ordinances, and in states, governor does it. However, it's an executive power of the president oblique governor, so it is done on the aid and advice of the Council of Ministers at the center or at the state. Basically, it happens to be a power of the Council of Ministers at the center, similarly at the state also. In the state of Bihar, several ordinances were promulgated. Many of them were re-promulgated, and they were not put to the floor test. So when they were not tabled on the floor of the house, they had to finally die down. They were zero, but they were re-promulgated. And in this process, there were certain ordinances which were made to live for years and years, up to 14 years. Some were made to live up to 12 to 14 years also. Petition was filed by Mr. D.C. Wadhwa, and court says this is a fraud on the constitution, because the constitutional scheme is towards filling the gaps if any gap is likely to surface. Executive can make a law in advance in light of our parliamentary democracy. I believe this ordinance making power has to be seen in light of parliamentary democracy. That means the Council of Ministers has to have a majority in the legislative house. If and so long as the Council of Ministers is enjoying majority in the legislative house, they are well capable of taking a decision which is easily going to pass the number test, the majority test in the legislative house. If there is something which is wrong, if there is something which is being avoided to be put on the floor, means discussion is being avoided, transparency is being kept away, things are not brought to light. When parliamentary house discusses several aspects, means all aspects of a law can be discussed, people are free to speak on it. But if discussion is avoided, that means the spirit of lawmaking lies in the legislative house. This spirit is violated. This is the reason why the Supreme Court said that this is a fraud on the constitution, and ordinances should not be repromulgated. However, there is no absolute ban on repromulgation of ordinances, but they cannot be repromulgated unless extreme exigencies are there, situations are there. And further to further, it is not going to happen. And it is very much made clear and strict now that every ordinance has to be tabled unless it is withdrawn. So this is something which is a very crucial example of judicial review of executive action. Though someone may argue that this was also a legislative action because it is ordinances and executive lawmaking, but action was taken by the executive. It was executive action. Had it been a legislative action, there was no problem and court would not have called it a fraud on the constitution. So this one example of judicial review of executive action is there in DC Vatva versus State of Bihar. And here again the court has been very activist. In the case of Satpal versus State of Haryana, another example, governor and president have the power to grant pardons, and in this case governor had granted pardon. Somebody was punished and the punishment was made final, and person applied for clemency. Governor has power under Article 161, President has under Article 72 to grant pardon and several other reliefs, which is possible. But this is an executive power of the President oblique Governor. So this power is exercised solely on the basis of the aid and advice of the Council of Ministers in center or state, as ever the case may be. In this case, it was exercised and the person was granted pardon. Court turned it down. This is a glaring example of judicial review of executive action, and court did it on the ground that all advices, all matters and all facts were not supplied formally to the president in a proper way. So president doing it in absence of complete data, this is not going to be a clear constitutional case of grant of pardon. Court intervened. This intervention is serious, and this is like an activist judiciary. Something wrong happening and court finds space to correct it. Very recently and much talked about Jallikattu ordinance, and finally Jallikattu was banned. Here also role of the judiciary has been towards activism. There can be certain aspects of culture which are in followance, but with passage of time civilization develops, and the development has to come to a stage where old practices are put to test. Those old practices are put to test means they may pass, they may fail. Here, if the developed civilizational ideals have confirmed that they are not passing the test, they are to be turned down. And role of the judiciary in this whole episode has been activist of an activist judiciary. The other aspect, the last point on this category, is about appointment of Chief Justice of India and other judges. This is a very important aspect. We have discussed it once earlier in the same discussion when we were talking about the advocates on record association cases. For the first case, evolving the collegium system, and the second case, turning down the NJAC provision, NJAC Act. Here, court had interpreted. Actually, activism happens a lot by interpreting the provisions of the constitution or provisions of any of the laws. Interpreting it would be also seen as a review of it, but necessarily not. Maybe a review may expand a provision or its scope or restrict it to some extent in certain cases. So, not essentially connected within the judicial review of it. So, I have kept it within the head of judicial review of executive action, because appointment of chief justice and appointment of judges is done by the president, and president does it in the capacity of being the executive head. So, the role of council of ministers is also important therein. This part also connects with the independence of judiciary. I'll mention some instances here. India from the very beginning was following the principle of seniority in the appointment of Chief Justice of India. There was never a question. But with passage of time, questions arose. Life becomes complex. So many claims are there. So many possibilities are there. So many options are there. It was discussed. And it was the judiciary which says that in the appointment of Chief Justice of India, in the appointment of judges, overall, the suggestion, the consultation of Chief Justice is not only supposed to be a formal consultation, it is limited to consultative capacity only. It is binding. It has to. Consultation is a must, and consultation must be taken to follow this. So this was judicial review of executive action. However, Judicial review of executive action can be discussed only on a case-to-case basis. So some cases are also to be taken. And that is to be seen in light of not only judicial activism but also judicial independence. The most celebrated case of Keshwanand Bharti versus State of Kerala was decided in 1973. And this case was decided by a majority of 7:6. It was a 13 judges. It was a huge bench of 13 judges, and the judgment came by a uh, marginal majority of 7:6. Nothing more about it. Case was decided. After this, the next appointment of Chief Justice of India saw some variation in the rules. Not much to speak on it on the constitutional provisions, but it happened that the next Chief Justice of India was appointed. He was not the senior most. He was not the senior most judge of the Supreme Court. In the order of seniority, three judges were superseded: Justice Grover, Justice Shileth, and Justice Hegde. And it is also not the case that the three judges were unwilling to be Chief Justice of India because they resigned in protest. Second instance. During emergency, the much talked about emergency of 1975 to 1977, when emergency is invoked, fundamental rights can be cut short, can be made inapplicable. So under Article 359, President promulgates an order. President has made had made an order, and the presidential order was in issue. That was the case of ADM Jabalpur versus Shivakant Shukla. It was a five judges bench in Supreme Court, and it was decided by a majority of 4:1. Issue was whether each and every fundamental right is open to suspension under Article 359 by an order of the President. Contention was that right to life can never be suspended. However, the 4:1 majority held that uh, it can also be suspended. After this, another instance of appointment of Chief Justice of India, and the judge in minority, who was the senior most, was superseded. Not the case that he was unwilling, because he also resigned in protest. Resigned, at least this much of fact can be claimed, objectively resigned, supposedly in protest. In the first case, when three judges were superseded, three senior most judges were superseded, petition was filed. But the petition could not give any relief. Because even if the seniority rule was to be enforced by a court order, then there were two aspects. One, court order would not have generated much of faith into the system. Court is interfering because it is judiciary versus executive. Could have been seen like that. This is my opinion. Second thing, since the senior judge and the senior judges had already resigned, so the person so appointed was already the senior most. So the thing that could have happened, even by the seniority rule, was that he himself was to be reappointed. Next thing, a sitting Supreme Court judge, without any charge on his working, no approved misbehavior, no incapacity, nothing, creating an issue with the judge, and the judge being in the Supreme Court means possibility of justice was also to be slightly made dimmer. Whether the judge was to resign means that was leading towards a crisis situation. So all these things are, I think, were likely to affect the process of justice. So a remedy did not come, but finally it came out to be a rule that only the senior most judge will be the Chief Justice of India, and the same rule is in followance. So all these things have happened by the activist role of the judiciary. Many a times it is said in India that this is peculiar to India that judges appoint judges. Still, judiciary has taken up an activist role to correct certain wrongs. These things have happened in a complete series of events and incidents, and there is a complete series of cases which justify the happening of these things. So the activist role of the judiciary is well justified on this front also, which is also an example of the judicial review of executive action. Now, taking up a specific thing which is about judicial activism and judicial interpretation. In fact, the whole lot of activism comes through interpretation only. Interpretation means interpreting the law. What exactly does it mean? Any provision, or maybe that the whole of statute is impugned, and at times it may be discussed. The biggest example is Article 21 of the Constitution, which everyone knows that is just a one-liner. No person shall be deprived of his life and personal liberty except according to the procedure established by law. It's one right, right to life, or you may call it two rights, right to life and right to personal liberty. But in effect, how many rights are included? That we all know means more than 100 rights have been held to have been included within this one liner provision, and that has happened only through judicial interpretation. Court has interpreted life is no life, life doesn't without dignity. Life does not mean a mere animal existence, it has to have some dignity. Minimum basic dignity of human life has to be attached to it. So anything that curtails that minimum requirement of dignity is violative of right to life. Right to education was held to be, in Mohini Jan's case, right to education was held to be a fundamental right within right to life, just because there cannot be a dignified life without education. So there are a number of cases in Olga Terrace versus Brihan Mumbai Municipal Corporation. It was said that without livelihood, dignified life cannot be thought of. So it happens to be a part of right to life. All this has happened by interpretation, and all these interpretations have been done by the judiciary, which is an activist judiciary. So judicial activism has a very important component with judicial, linked with judicial interpretation. Appointment of Chief Justice of India and the Advocates on Record Association case is relevant under this head also. And since those things, the legal questions, the legal concerns have once been discussed, so I'll not repeat all those things, but I'll just try to justify the relevance of this bullet point. This is also part of judicial interpretation, because in all those things, judiciary did not, no new law had come. It was all about interpretation. Constitutional provisions were interpreted, except the NJSC Act. That was a new law. In all other cases, it were all interpreted. And even in this case, the judicial review of legislative action part of it, it was all, the law was interpreted for its validity, interpreted and then tested for its validity and constitutionality. So this part is relevant here. I have an example, very clear example of the Minimum Wages Act. Minimum Wages Act is uh, for providing the minimum wages for certain sectors. There are schedules at the end of the act. There is a schedule given, and the sectors listed in the schedule, for them minimum wages are to be prescribed by the Minimum Wages Board. And section 27 says that the state governments may also add to these lists. State government added to it. It was challenged. It was challenged that state government cannot add to it. It was court which interpreted and found that state governments are more directly connected to the grassroots level of operation of things and the economic necessities, the economic needs, and the economic compulsions. For that, legal intervention has to come in line with the economic requirements. That is the purpose of Minimum Wages Act. So if there is something which is state specific and the state government is of the opinion, they can make a state amendment, they can make an addition to that schedule, and for that also minimum wages can be prescribed. It was held constitutional by the Supreme Court by proper interpretation. Interpretation is not only of a word or of a sentence or of a provision. Interpretation is a test of validity to be in line with the complete statutory scheme and the constitutional scheme, because the legal provisions are well connected in a rhythmic way, provision to provision, the whole of the statute, and then it all connect with the constitutional ideology. That's why statutes and provisions are tested for their constitutionality. And that's why in the principles of judicial interpretations, one of the important principles is reading the statute as a whole. The whole statute is to be read, then only the statutory scheme could be understood, and then only a proper test could be conducted for its validity and constitutionality. There are other cases also, like those of Arnesh Singh versus State of Bihar. This is a case on arrest, though the case was directly about arrest on matrimonial wrongs, but since it provides for something related to arrest, the basic law on arrest is that person is arrested for broadly two reasons. One, that he is likely to flee the process. Second, that he is likely to tamper with the evidence. If the person is not likely to flee the process and the person is not likely to tamper with the evidence, then what is the point in arresting a person who is not proven guilty? Because the principle is, unless proven guilty, he is innocent. So why to imprison an innocent? This is done under apprehensions of these two things as we discussed right now. In this case, it was confirmed that arrest is not supposed to be made essentially in all cases of dowry prohibition. If there is a case, police will evaluate whether arrest is needed or not. In fact, and in practice, police does evaluate. But there are certain wrongs which are so serious that they don't take chance. They arrest it. Court had to confirm that no. In the name of not taking chances, arresting compulsorily would itself be violative of justice. Because essentially arresting is something, means it cannot be correct in 100% of the cases. Maybe in 90% of the cases it is correct, but it cannot be correct in 100% of the cases. And more so, to point out, I'll take opportunity of pointing out that the law of dowry and the law of matrimonial wrongs, they were all made to protect a particular class of the citizen, particular class of the population, that were the female gender. They were offered this protection and extra support by the law because they were towards vulnerability. A lady comes to another house, she is automatically becomes vulnerable. If anything wrong happens, she is the vulnerable. So law had to come to protection. Dowry was an evil which had to be resolved, which had to be eradicated. Law interfered. How far has been successful is not a matter of discussion right now, but the current of legal flow and the regulatory rhythm was towards ensuring safety, security, support to women, and towards eradication of these wrongs. But the support from law was a current flowing in a particular direction. And these social currents and then induced legal currents that keep flowing in a particular direction towards justice. When it comes to the regulatory currents, there are chances of misuse. There are presumptions in the Evidence Act also, which lay some empowerment to the lady victims. No one can say that it shall never be misused. But the composition of the society at the time when the law was made was very much like to make it unlikely that they are going to misuse it. There would be rare instances when it was misused. But with passage of time, when all component of society, community, culture, everything is developing, the possibilities are also changing from here to there. And when the social currents are created from the contrary direction, legal current also has to come in response towards protection. The social current was towards dowry and all. Legal current came to protection of women. Social current was creating a need for protection of women. Legal current came to protection. The counter current started in the social direction. When the counter current has started in the society, the counter current in the legal side also would have come. This did not come from a statute. This came from a judgment. This countercurrent means the possibility of misuse and a check over it. This has not come from a statute. This came from this judgment. So this justifies not only an instance of judicial activism and judicial interpretation. This is also an instance of judicial activism which justifies the activist role of the judiciary. Coming next to the um, next example is Mohammad Hanif Qureshi versus State of Bihar. So without getting into the details of the case, I'll simply say that in this case there was a conflict. The issue was regarding a conflict between fundamental rights and directive principles of the state policy, part 3rd and part 4th of the constitution. And court was of the opinion that fundamental rights are superior. However, this was one interpretation done much earlier when the constitution was new. Later, almost 15-20 years later, case of Minerva Mills came, and the same constitutional provisions, the same part 3rd and part 4th was interpreted, and the constitutional scheme was found to be that there cannot be any conflict between part 3rd and part 4th. Court says if there is any apparent conflict, it has to be harmoniously interpreted to avoid the apparent instance of conflict between fundamental rights and directive principles, because both of them are parts of the same constitutional scheme, and the same constitutional scheme cannot have the means intersecting currents. It has to have a unified rhythm. They are part of a unified rhythm, so there cannot be any conflict. This came through interpretation, and this is also an example of judicial activism. And next to it is the case of Keshavananda Bharati, which is one of the most celebrated judgments in the Indian legal history. The judgment has so many components on it, but the thing which is relevant here, that is about the power of the parliament to amend the constitution, which is again a legislative exercise, but it is judicial activism that court came up to provide a new doctrine, lay down uh, certain features of the constitutional scheme, and the court said Parliament's power to amend the constitution is unfettered. They are very powerful. They can do it. There is no restriction, but the only thing is that they cannot affect the basic features. They cannot damage, they cannot alter the basic features of the constitution. Constitution has certain basic, important, inherent, and unchangeable features. Those cannot be amended, and these things are abstract in nature. That's why court did not give a complete list of the basic features, but on a case-to-case basis, courts have been propounding that this particular thing is a basic feature of the constitution, or maybe that this particular thing is not a basic feature of the constitution. It is also said that by this judgment, court has retained the whip in its own hand whenever time be court can crack it. But there are so many examples of self-restraint observed by the judiciary in India that it is very unlikely that courts are going to misuse it. However, it only provides a second opportunity to review whether the constitutional amendment is really leading towards justice or really leading, is going to fulfill the constitutional scheme or not. Now, taking the bigger issue which is generally discussed in the interpretation of statutes classes, and also in constitutional law classes, judicial activism and judicial lawmaking. Can judges make law? Is judicial activism so justified as to be uh, able to permit the judges to make law? Basically, the answer will come in negative. Judges are not supposed to make law because there are certain limitations on judicial activism. They can be active, they can fill the gaps, but they cannot be allowed to cross their jurisdiction. Many a times, commentators have written, it is many a times observed, seen, said that in the spirit of judicial activism, courts have been seen standing on the extremes of its jurisdiction. May be true, but none of the instances are criticized for their justifiability. They are not said to be beyond the constitutional scheme. So they are correct. But no doubt there are certain limitations on the judicial activism also. Judges are not elected. Judges lack in democratic character, and India is a democracy. In the name of judicial activism, in the name of conforming to the ideals of justice, the elements of democracy which is held to be a basic feature of the Indian constitution, they cannot be diminished. So the democratic institutions are to be strengthened. So their task cannot be taken over. Basically, the function of lawmaking is given to the parliament, to the legislature. They should be making, and court should generally refrain from engaging into the domain of lawmaking. So the answer would always be in negative. Judges are not supposed to make law. They don't make law, but there cannot be an absolute yes or no to it. We always refer to the famous statement of Lord Denning that judges cannot sit with folded hands and see and be the mere spectators of injustice happening. They have to take up some activist role, and they have to devise some mechanism within the existing structure and framework of the law, if it is possible. And this all is done through interpretation. Many a times, this interpretation is so liberal as to amount to a lawmaking. There was an instance when about disinvestment court intervened. Primarily, primarily looking from a distance, everybody will say that disinvestment is a policy matter which has to have democratic character in its exercise and assertion. So court should have refrained from intervening in it. But when you see the judgment, court had a ground to intervene. That's why we often say that if on a case to case based analysis is done, the judiciary is not likely uh, uh, to be standing on the outside jurisdiction part. So they are within jurisdiction. In that case, court simply said that court did not say that disinvestment of these companies government corporation cannot be done. Court said these were established through statute by passage of a statute. So there is Disinvestment would always require a specific statute, means a law-making process to be followed. And after that, it could not be done. That's a different thing. But the judicial approach towards it was well within ambit. There are limitations, and judiciary has been serving its role, even the activist role, within those limitations, within those boundaries. Even courts have said on several occasions in certain cases that courts cannot pass a writ of court cannot pass a writ of mandamus for lawmaking. Court cannot pass an order that make this law. Court cannot pass such order. In case of Sarala Mudgal, regarding Uniform Civil Code, the Supreme Court had passed an order of initiating the proceedings for, which is a democratic function. Court generally don't order, courts should not be ordering it. So that then the next case, Lily Thomas case, the courts have been seen explaining it that that was in obiter. This is a technical element of law and jurisprudence, the ratio and obiter thing. But the court is seen confirming to lie within jurisdiction by saying that so and so statement was in obiter, not in ratio. It was not an instruction. It was an expectation. And on this point, there have been so many judgments in which the courts have expected the expectation that this will be done. This is a need of the time. Not only Sarla Mutkal, but Jordan Diengde, Lily Thomas, Daniel Latifi, courts have said that it is a need of the time that a uniform civil code be made. But this is a statement which lies in obiter, not in ratio. So courts cannot be said to be crossing the jurisdiction for these examples. However, there is one example which can be discussed, though the judgment, the case was not questioned when it was given. In Bangalore Water Supply and Sewerage Board versus A. Rajappa and others, Supreme Court has given a completely new definition of industry. The definition of industry given in the Industrial Disputes Act was not found to be sufficient and clear enough. Court substituted it with a fresh definition. According to the principles of interpretation, it is not to be done. However, court did it, and no one did criticize that the judgment is wrong or the early judgment was good. So for technical legal reasons, a just action cannot be termed as unjust. So this is also not seen as judicial lawmaking. It is only seen as interpretation of the law. In Vishakha's case also, court gave certain guidelines which are seen as lawmaking, but it is also seen as interpretation rather than lawmaking. And the example of Article 12, this is an example in which it is said, and I feel that the legislative scheme itself was inviting judicial intervention towards completing the law. The words state means and includes. State means and includes union government and its parliament, state governments and their legislative assemblies, municipalities and local authorities and other authorities. The word other authority is itself an invitation for the judiciary to come, interpret and clarify what all things are, what all authorities are included within other authorities amounting to state. So it cannot be said that lawmaking is a segregated exercise to be performed solely by the legislature. It has so many stakeholders and so many contributories to it. This example confirms that judiciary is a contributory to lawmaking, but this lawmaking is not seen as a formal lawmaking. This is only filling the gaps or interpreting the law. One more example is there of the rarest of the rare doctrine in the award of death penalty, in which court has only given out a doctrine how to apply, how to award. Court has not made the law. However, it is well confirmed that this is something new added. But we can compare it before the rarest of the rare doctrine was given in Bachchan Singh's case, and after this judgment. Things are not much different. Only difference is that what was being exercised was being done under vague situations, on vague grounds. All that has been brought to clarity, and some objectivization of the thing has been done. To this effect, this judicial interpretation or judicial pronouncement of doctrine has been very positively towards contributing to attain the goal of justice. Coming to the fundamental rights, I'll only take some examples. Right to equality. Equality is something abstract, something absolute. Article 14 is the repository of right to equality, which says that state shall not deny to any person the equality before the law and equal protection of the laws in the territory of India. This is done about equality. But why do we need Article 15, 16, 17 and 18? Had it been so complete in Article 14, then why do we need 15, 16, 17 and 18? That means this law is given in abstract way, and there cannot be a full-fledged, complete law which does not ever need an interpretation. Court has done some activist interpretation of it, and in E.P. Roypa case it was said that any arbitrary action is violative of equality. The cases in which court has said that equality prohibits discrimination, but equality demands classification. When separate classes are there, then classification has to be done. Otherwise, it amounts to a discrimination. Equality has to be implemented among equals. Similarly, on the reservation policy, also in the determination of backwardness and several other issues of proportionality, how much of reservation. On all these fronts, Supreme Court has courts have guided the, the policy of reservation towards a certain direction to make sure that it lies within the ambit of fundamental rights. The cases starting from Champakam, Durairajan and coming up to Indira Sani, at least Indira Sani, if not beyond. Then this is a complete code on this reservation policy. The guidance has come from the courts only. However, courts have also exercised self-restraint when something was laid down in Indira Sani's case and that was nullified by making a constitutional amendment, by passing statutes. Courts exercise self-restraint because there's nothing about which courts have to ensure their authority. Something guided towards a particular direction, and out of all that, very much like a legislative scheme, something is inviolable and something is open to democratic lawmaking legislative exercises. And if that happens, there is no dispute. So here, activist role and exercise of self-restraint both have balanced the role of judiciary in such a way as to be nicely balanced. Right to education is an example, which I have already mentioned, that is a component of dignity. In present day circumstances, no one would disagree that a dignified life is not possible in absence of education. A person has to be educated. So, in Mohini Jain's case, court held that right to education is a fundamental right. Same in Unnikrishnan's case, with certain additions, which was likely to be a further evolution of right to education. But before the further evolution could happen, an 86th amendment was made in 2002, and Article 21A was added. And further to it, a Right to Education Act was made, and governmental schemes and policies are acting strongly on it towards ensuring the right to education, which happens to be a part of right to life. The basics of right to life, starting from A.K. Gopalan, coming up to Menka Gandhi, the procedure established by law, whether it is the procedure established by law, whether it means simply through the procedure of law or it has some adjective qualification also. In Gopalan's case, it was said no, it does not have any adjective qualification. If it is done through the process of lawmaking, it's final. But after about 25-26 years after the Gopalan judgment in Menka Gandhi case, it was confirmed that it has to be. The procedure established by law has to qualify certain uh, adjectives. The procedure established by law has to be fair, just, and reasonable, and it cannot be fanciful, oppressive, and discriminatory. This development has happened merely by the activist role of the judiciary, and there can be many more cases. As an example, between Gopalan to Menka, starting from this Ram Singh versus Delhi administration, coming up to Bennett Coleman case, and Menka Gandhi case is one of the celebrated cases which conforms to this change of opinion. In Permanent Katara, the activist judiciary came up to declare the rights of the victims of road accidents. Court said that official formalities, police formalities, and all should not come in between, and he has a right to get immediate medical health. This is a fundamental right within right to life. Similarly, in Indian Medical Association versus VP Shanta, court also held that a person who goes to a hospital, he is a consumer. Any deficiency in service, any case of medical negligence can be seen within the jurisdictions of consumer protection also. Means taking things into fundamental right domain and allowing things into different domains so as to empower people. This is the scheme of the constitution, and this is fulfilled through the activist role of the judiciary, which has been positive. Out of all these examples, it appears just that. And one more example, the last example of this category I'll take, this is towards environmental conservation. Judiciary has been very active towards environmental conservation. It is said that the environmental law has seen two major stakeholders in India. One, the international forums. It has basically flown from the international forums and then came to national lawmaking. Second is the judiciary. And if any third contributory that can be said, there is about the hazards that have happened. The Bhopal gas leak disaster is said to be a major incident that led to the strengthening of law and institutions towards conservation of the environment. But before that, a case happened in the municipal council Ratlam versus Vardhichand and others, where population of a city was suffering from the unhygienic condition in the jurisdiction of the municipality. Here, Section 133 of CRPC is a provision which allows the subdivisional magistrate, the executive magistrate, to pass a conditional order for removal of nuisance. The citizens finally, when it was completely unworthy of living, they had no other option. After having pleaded a lot, written applications and letters, they were left to nothing. Then they started exercising and asserting their rights. They wrote to the executive magistrate to take action under Section 133 of CRPC, and the magistrate wrote an order that the nuisance be removed. Here, the party who has been subjected to this conditional order, the party has a right to come back because it's an ex party order. Party has a right to come back to the executive magistrate and explain the reasons of why the nuisance cannot be removed and why the order is not to be made. In spite of coming to the executive magistrate, they filed a writ petition in the High Court challenging the jurisdiction of the magistrate. High Court ordered in favor of the municipality. That municipality not doing anything is one part, but this executive magistrate does not have any jurisdiction to pass such an order against the municipality. The citizens did not lose heart and they filed a petition under Article 32 as a matter of fundamental right now, and they went to Supreme Court, and the Supreme Court confirmed the order of the executive magistrate. And court says whatever is the constraint, the right to life includes the right to live in a clean, healthy, and worthy environment. If this environment is getting affected, then fundamental right is getting violated, and no excuse can be taken on this point, and municipality has to work. Since then, Section 133 of CRPC has been utilized on a number of occasions to enforce environmental rights. Subhash Kumar is a case in which a right to clean and healthy water and clean environment was held by the Supreme Court. Rural litigation entitlement Kendra is an example in which indiscriminate mining towards degradation of the environment was happening, and court did put a stop on it. MC Mehta and Kamalnath cases are also very important examples. In the Kamalnath case, the MC Mehta Kamalnath case, court has propounded the public trust doctrine. All the natural resources of the country are in the capacity of a trust, public being the beneficiary and the state is the trustee. They have to manage it so as to be available, so as to it all be available for the benefit of the beneficiary. Any loss to it should be recovered, should be restored. And here, order was passed against the private party, the motel owner, who had degraded the environmental conditions, and the cost of recovery was also, cost of restoration was also recovered from them. Here, public trust doctrine happens to be a very important doctrine towards environmental conservation, and this case was decided also under the jurisdictions of fundamental right. So, this is big example of judicial activism. And TN Godavarman cases were a series of cases filed for protection of forest. This forest conservation has been a concern also in the Rio Earth Summit, the first Earth Summit. The certain principles on forests were adopted, but the law was not being implemented at the grassroots level. Concern was everywhere, from international to national forums. In this case, court laid down comprehensive guidelines for conservation of forest. So I take this also as an example of judicial activism towards conservation of environment. Now, towards concluding it, we'll evaluate how far the courts have been justified in doing it, how far the courts have been within jurisdiction. I don't claim that courts have been correct all along. Maybe that there are some examples where it may be debatable. There may be examples which are debatable, but I am strongly of the opinion that courts have been within jurisdiction. And whenever courts came up to the extremes of jurisdiction, there was no crossage of it. And second thing, courts have done it very, very justifiably. So sufficient justification for it is there. No doubt, the justifications for judicial activism will also take into account the lapses on the part of legislature and of the executive. If executive and legislature are performing their role very actively, then judicial activism would not be much required. This is true. However, no one can claim to be flawlessly working, so gaps may appear and filling of gaps may also I take it as an example of this filling of gaps only. And judiciary has ensured sufficient self-restraint and sufficient transparency in its processes so as to ensure justifiability of all instances of judicial activism. Limitations are no doubt there. Courts cannot make a law. Courts cannot pass an order for making of a law. It is now confirmed by number of judgments that court cannot pass an instruction that make this law, pass this statute. If there is a law which lays down a duty, that duty is not fulfilled, then court can order that do this under this law. That is possible. So there are certain limitations, and I am strongly of the opinion that courts have been within jurisdiction and within justifications. So thank you very much. And if there are questions, they are most welcome. I'll be happy to answer. Thank you. Thank you very much.